I was just kidding before. This is my final video. Crim law. Inchoate offenses, attempt crimes, uncompleted, should be lighter penalty from substantive crime, but MPC treats them the same. Way to not try to deter people from maybe stopping before they go too far. Okay, so the order is solicitation happens when it is communicated. Once it is agreed to and there is an overt act, it's a conspiracy, and solicitation will fall away. Once it's attempted, it's attempt, although we've got a lot of like rules for attempt. So you can have attempt and conspiracy, but once it's finished, it is the underlying crime. And in the common law, conspiracy, attempt drops, conspiracy stays, attempt drops away. But in the MPC, conspiracy drops away too. And if that's wrong, I'm going to say it a bunch, and I've got it written. So that'll help us. So mens rea. Common law says specific intent is required. Purpose to commit the crime is required, even if the underlying crime would have required less. So malignant heart murder, recklessness, your intent wasn't to commit that crime. But to have one of these attempts, you need to your mens rea has to be to attempt. And then we have the model penal code where mens rea established for the defendant's acts, what kind of culpability otherwise is required for the crime will be required for these attempt crimes. So the hypo is shooting into a car with the intent to scare but not kill. Common law would say this isn't murder because that was not your intent. So malignant, even if it would be malignant heart murder, the attempt crimes won't reach that because the intent wasn't murder. But the MPC says no, it's malignant heart murder. You all had that intention, so you're all gonna be on the hook. So the actus reus, so that's the mens rea for all of them, really. But it's a little, okay. Anyway, we're just gonna jump right in. Solicitation. Complete when solicitation is made. So this is the asking someone to do a crime with you. If the underlying crime is attempted or committed, this merges with attempt, conspiracy, and or the crime. So you're only gonna get it for solicitation in general. The solicitor likely becomes an accomplice, and the person solicited to do the crime becomes the principal. So when you have multiple people, you're going to look for this crime. And the definition of solicitation is inviting, encouraging, directing, or inducing someone to commit a crime. The actus reus is inviting, requesting, commanding, hiring, encouraging, inducing, all of those things we just said. And in common law, D's message must be conveyed to the person. If it never makes it, then it's not solicitation. But the model penal code says the attempt to convey is enough. So our case for this was a letter that went out from prison, but it never actually went out. Under the model penal code, guilty. Under common law, not guilty. And the mens rea is that you are intending to ask them to join a crime. It can't just be you tell them about it and they're like, oh, I want to join. No. You're asking them to, and it's a specific intent that you're asking the other person to commit the crime, not just be a part of it. You're asking them to commit the offense. So that's solicitation. And then we have conspiracy. Upon agreement, so solicitation has happened, there's an agreement, and then there's an overt act by the conspirator. Common law says this does not merge if a crime is actually committed, but the model penal code says it merges. conspiracy stays. But in the model penal code, it goes away. So the what do you call it? The university scandal. They're being charged with fraud, and they're being charged with conspiracy. So they must be under common law or statute. Okay, so again, if there's multiple people, you're going to look at conspiracy issues. The mens rea required dual specific intent to agree to do the crime, and specific intent to accomplish the illegal objective. Even if the specific crime does not require intent, they need to intend to do something illegal, do this illegal, not just something. And then sellers, if it's a seller, so this was our phone answering service case, sellers to criminals are only conspirators if they have knowledge of the illegal use, which he did know, and they have purpose to further the use, special benefit, or seriousness of the crime. And in that case, like, they were just using a system like everyone else. He didn't charge them more, he didn't charge them less. So they said, well, he's not a conspirator. And then the actus reus, you're going to look at agreement and an overt act in furtherance. It doesn't take much, but it's got to be something that they do, and does not need to be simultaneous with the crime. So it could be renting a car to be used in the crime. They do something. And then here we have a bilateral and a unilateral rule. So the common law is bilateral, and it says multiple conspirators required. Everyone needs to be in on it. So this, if one person is setting another person up, so one person is planning to actually do the crime and the other person is totally not going to work. But the model penal code says this one person in, one person out, unilateral is fine. Only one person is required. Being set up is allowed. We love justice. The crime never has to be committed to be guilty of conspiracy. And so we have a few like residual rules for this. So vicarious liability rule of Pinkerton says co-conspirators are liable for every crime another conspirator does within the scope of the conspiracy. But then we have to look like, are they actually in the same conspiracy or are they in different? So like there was one conspiracy to kill a man, but two guys were in on it first, and then two other guys did it, and then these two split up, and this one did this one. So they were saying like these guys were in a conspiracy, but these two that they had no knowledge of and weren't a part of, like they couldn't be. So the prosecutor wanted to use the wheel conspiracy for them and say, hey, there's the guy who bought the hit is at the center of this wheel, and then he hired you guys, and he hired you guys, and he hired you guys, and so you're all part of this wheel. But because they didn't know about each other, there was like no rim, as Coach says. Although it was the same target, but I guess the target cannot be the rim of the wheel. So like knowledge of each other. Because what they lost on was, no, it was a chain. They did it. No, they didn't. They said it was a wheel and there was no rim. If it had been a chain, so you do it and then you do it and then you do it, the hypo for this is like smugglers who give it to a middleman, who give it to retailers who then sell. They know that there are people in this chain, and so they are all culpable for what everyone in the chain does. And in that case, they're all culpable. But in the wheel, if nothing's attaching them on the outside, they're not going to be. So everyone in the chain knows, and it continues, so everybody's guilty. So why do we want co-conspirators? Because in court, heresy, no, not heresy. That is not in the court, that's in the church, and that's hopefully not. Hearsay is admissible between co-conspirators, but not for other people. So if they're co-conspirators, then they can play that game. The model penal code doesn't like this rule, and because they're trying to find individual culpability. So they do not like the Pinkerton vicarious liability rule, where co-conspirators can be tried for everything that their friends do, or not their friends. Okay, and then we have some defense against conspiracy. And that's Wharton's rule. And Wharton's rule says it takes two, baby. That's Wharton's rule. Sorry, that was a mosquito. Adultery, bribery, dueling, incest, it takes two. So it takes two to do those crimes, and if those are the only two in the crimes, it will merge. Conspiracy will merge, even though it traditionally will not. The part of this is like the penalty for those things has already been considered, so and added to those crimes. So you're not going to get an extra conspiracy charge, but there is the Iannelli rule or Lanelli rule. I'm not sure how to pronounce it, but there it was about gambling, and it was about like 5 or more people, and the Supreme Court said no, they can also get conspiracy because it's public interest to try to not promote that crime. So they're not going to give you Wharton's rule for that. I think that's silly, but whatever. Not going to be on the Supreme Court ever. So then we have the protected party defense. If a statute is made to protect someone, then the party to be protected cannot be charged as a conspirator. So the Mann Act was to stop human trafficking, and they can't charge the prostitute as a conspirator. Even if they are not being human trafficked, they are willingly going. If they meet the elements, they can't be a conspirator. They can be charged with other things, but not a conspirator. And then there is also the defense of abandonment. This must be voluntary, so if you're being chased by the police, not voluntary. But common law says the defendant must notify all co-conspirators, which might be hard if he doesn't know them, like in a chain, whatever. But the Model Penal Code says that notifying the police can be enough. This is only a defense for future crimes. It won't get you out of past crimes, and not for crimes already committed. And prosecutors want conspiracy because, and he said we don't need to know these, but they'll be helpful to know. Heresy between co-conspirators is admissible in court. Everyone can be prosecuted together. Jurisdiction can be the place of agreement or where any of the acts by the co-conspirators was committed. And the statute of limitations doesn't start until the last crime is committed. And then we have attempt crimes, and this requires an act beyond preparation, and it merges with the underlying crimes. So we look at the different jurisdictional tests for this. Okay, we looked at the jurisdictions for this. So there are 4, and we have substantial step, strongly corroborative of intent. We have dangerous proximity. We have unequivocality, res ipsa loquitur, and then we have no indispensable element. So substantial step, strongly corroborative, is backward looking. We look at all the steps that have shown, and we see if the D looks like they have what has been done towards completing the crime. And then we have the dangerous proximity, and this is looking forward, and we say, what does the defendant still have to do? This is a balancing test, so how close has the D physically come to completing the act, but also how great is the harm? And if the harm is great, we're gonna say they need to be less close. And if the harm is not so great, we're gonna say, you need to get closer before we say. But this is forward looking. Substantial step is backward looking. And then unequivocality, res ipsa loquitur. I like this one. This is what we call the silent movie. And so you look, and if it shows if the actor's conduct objectively and unequivocally manifests its commitment to the intent to commit the crime, then we keep going. But if they like do all this stuff and then they start to turn around and like abandon, like silent movie. Obviously something's going on and they're rethinking. And then we have the no indispensable element, and this is not widely applied, and it's basically saying, is there anything left to do? If there's anything left to do, then we're not going to go for attempt. This could be like you shot a gun, but you missed them. You had bad aim, and so you didn't kill someone, but it was attempted murder. So most don't like that one, not widely applied. The substantial step, strongly corroborative of intent, is the Model Penal Code. And those are the only ones I have labeled. And I went through every single note that I own, so that's it. And then assault, attempted but uncompleted battery. Okay, so I don't know why assault is right here, because it's an attempt crime, I guess. Assault, attempted but uncompleted battery. So you're gonna look for threats, attempt to commit a battery, a harmful or offensive contact, coupled with the present ability to commit a violent felony, no, a violent injury, or 2, subjection of the victim to reasonable apprehension of a battery, or conditional assault, threatened battery if victim doesn't obey the defendant. However, the Model Penal Code, assault includes cases where there is contact. So that's why they call it assault and battery. But for the purposes of this case, we did not learn the elements of battery, but it could be on there. He could give us the statute. So, inchoate defenses. You have impossibility. So you have a few different ones. Pure legal impossibility, which is weird because this is like D believes he is breaking the law, but he is not. This is not really a crime. All agree no criminal liability. Then we have factual impossibility, and this is not a defense. And then we have hybrid legal impossibility, which is a defense, but most impossibility cases are classified at either, and this could be shooting an already dead person. It's impossible to commit murder for someone who's already dead. The Model Penal Code rejects impossibility defenses. D is liable for his actions where he believed them to be, except for pure legal impossibility. So if it's not a crime, you're not going to be charged with a crime. But if you thought you were going to murder someone and they were already dead, the Model Penal Code says you can be charged, which I think is ridiculous. And then we have abandonment, which Coach tells us to remember CAV, complete renunciation, abandonment before completion of the offense. Some courts say before last proximate step, voluntary abandonment. And then last but not least, I think I already said last but not least, accomplice liability. So this used to be super complicated. We're not going to be super complicated because the law is trying to make it easier. So accomplice is one acts and the secondary party is guilty of the offense as well because of their assistance, aiding and abetting, soliciting. This will also be on the hook for conspiracy. You're going to look for the actus reus, assistance. This could be psychological, getting supplies, encouragement. Generally, mere presence will not suffice. Stating they won't interfere is enough. Offering to help. Stating they won't interfere is enough. Offering to help before is enough. Jury will decide if in fact something did provoke or help. Our hypo was breaking into the house window, and if you unlock the window but the primary uses a different one, no help, unless you can prove that it was encouragement. But if you unlock a window and the primary uses it, but all the other windows are open, so it wasn't even necessary, you still helped. So there'll be culpability there for the accomplice. Rule: the second must actually help, but need not be the but-for cause. The majority rule is you use the intent of the underlying crime. So whatever the underlying crime needs, that's what the accomplice needs. But the minority rule is you need to have an intent to assist. Someone feigning to help set the primary up, intent to assist is there, but not the underlying crime. So that would be where it would get, not uphold it. What can rise to the level of accomplice? Not mere knowledge, must be something else. And then reckless or negligence. So if releasing a lion from the zoo and someone dies. Reckless driving in a school zone. So that could raise you to the level. Derivative liability, accessory. The second party will only be on the hook if the underlying crime has been committed. So an accessory after the fact, this is the only one we have left for that. Assist the felon to avoid detection, arrest, trial, or punishment, can be guilty of no higher crime than the principal. Majority rule, MPC, California, federally. Accessory after the fact is a separate crime, generally with lower sentence. All the others are subject to liability as principles. And then we have natural and probable consequences doctrine. When P goes beyond the primary. When the primary goes beyond and does an additional crime, if it's natural and probable, hence foreseeable, then yes, the accomplices will be on the hook for it. The accomplice is bound to what is foreseeable. Must primary be charged first? Traditionally, the answer was yes, but modernly, nope. Second can be charged by himself and need not get the same deal as the primary. Hung him out to dry. Primary is innocent instrumentality. Okay, so what if the primary is innocent, like because he was under duress? If you don't steal this money, I will kill you. Primary uses defensive duress. Manipulated instrument will usually fit here as well. So they can use defenses to cut their liability. And then the defense's justification, secondary can raise anything the primary does. So if it's self-defense, defense of others, same thing. But excuse only works for the one alleging why they were intoxicated or insane or under duress. So duress might work, but intoxication and insanity is not going to work for a second. They can't tag along on it. And even duress, they're going to have to build it by themselves. So that's it. The legislature, a defense could be the legislature has exempted a party. So in a 15-year-old can't consent. And then you also have the defense of abandonment, but the abandonment must have been communicated to the primary and they must have tried to neutralize their help. But if it's just mere encouragement, then communicating can be enough. And that's it.